Before this hearing even begins, you can already feel the tension in the room. This is not just another routine eviction case, this is a collision between contract law and human hardship. On one side, we have the landlord's attorneys seeking a writ of possession. No money judgment, at least not today, but possession of the property. On the other side, we have a tenant battling heart failure, claiming partial payments were accepted, alleging promises were made, and insisting she tried to do the right thing. But here's where things get complicated. The lease expired, the rent increased, payments were partial. Management changed hands, and somewhere in that transition, communication, or maybe trust, broke down. The tenant says they agreed to work with her. The landlord says the contract speaks for itself, and in eviction court, the written agreement usually wins. This case turns on a crucial legal principle. Can a verbal agreement override a written lease? And what happens when someone is trying to pay, but not paying the full amount demanded? Stay with me, because the judge is about to walk through the numbers, the lease terms, and the legal reality of what happens when rent falls behind. And when the ruling comes down, it's going to be fast. Now let's step inside this courtroom.
I'm going to ask a couple of questions. I did see that the complaint asked for possession only. I did see, however, that it asked for rent in the future, but obviously at the time it was asking for possession only in December. Is this a written lease?
Yes, Your Honor.
Oh, I'm sorry. I'm talking attorney Sinkway. Is it a written lease, counsel?
Yes, Your Honor, and it defaulted to month on or about July of last year, July 5th.
Okay. And how much is monthly rent?
Under the natural lease, it was $13.60, and month to month, it has been $14.99.
Okay. Any late fee?
Yes, Your Honor. The late fee is $100.
All right. Last time tenant paid rent?
Last payment was received on October 30th in the amount of $100. It left an outstanding balance of $3,987 at that point.
Right here, this is the flashpoint moment. The attorney lays out the timeline. Last payment received October 30th, only $100, leaving nearly $4,000 outstanding. And immediately, the tenant pushes back. That's not true. That's not just disagreement, that's a credibility issue forming in real time. In eviction court, documentation is everything. Judges rely heavily on payment ledgers, lease agreements, and written notices. If the landlord's records show an outstanding balance, the burden shifts to the tenant to produce receipts, confirmations, or proof of additional payments. Now here's the key legal tension. Even if she made partial payments after October, unless those payments satisfy the full amount demanded under the lease, they may not legally stop the eviction process, especially if the landlord issued a formal demand for the total balance. And notice the judge's tone, calm, methodical, giving her space to speak. That's important. The court isn't dismissing her hardship. But hardship alone doesn't cancel contractual obligations. Let me ask you, if you were in her shoes, struggling with medical issues and trying to chip away at the balance every 2 weeks, would you expect the landlord to hold off on filing? Or is business just business? This is where emotion meets contract law.
That's not true.
Okay, well, give me a second. I'm going to give you an opportunity to speak.
I apologize.
Yeah. All right. Anything else, counsel?
Not at this time, Your Honor.
All right. So I'm going to ask you some questions to confirm, Ms. Stevens. Ms. Stevens, do you have a month-to-month agreement with the View?
I thought I was still in the lease. I never knew a month-to-month. So I thought they raised my...
When does the lease that you believe you were under, when does it expire?
It was supposed to expire in July, August.
Okay, and that's what he's saying, it expired. Did you sign a new lease or did you just keep paying rent?
I just kept paying rent.
Okay.
They switched ownership.
Yep.
So when they switched ownerships, we never knew that until we went into the office and seen new people. I asked to downsize. They would never let me downsize because they said I was still in the lease. That was the old management.
Mm-hmm.
So when the new management came in, everything just went left.
Okay. Well, last time you made a payment?
The last time I made a payment, it was in November. It wasn't December. I was paying every 2 weeks to try and get my balance down because I was out of work for heart failure. So
Yeah.
I was trying to get my balance down. And they told me they will work with me as long as I'm paying something every 2 weeks.
Okay.
I have witnesses to that. I also have a recording to where I was trying to pay my rent before I even got a letter on my door, and they would not take my money.
And once you got that letter on your door, did you try to pay that money?
I did. I called the office, and the lady said she could not take my money
Were you
because
trying to pay the full amount or a partial amount?
I was trying to pay the full, well, not the full amount, but majority of it. It was all,
That's a partial. That ain't it. That ain't it.
well, they wouldn't take my payment regardless.
Gotcha.
That was before I even got a letter on my door.
I understand. All right. Well, initially they weren't seeking any money judgment. They were just seeking a writ of possession.
Correct.
You know, I did see in your answer you indicated that they owe you a grant that you referred to folks over there.
Yes, I did. I referred folks over here. But my thing is, we wouldn't be in a writ of possession if they had honored their word. They led me wrong. If they had honored their word, we wouldn't be here because she told me as long as I pay every 2 weeks or whatever, they wouldn't file against me. I have witnesses to that. I'm
And I,
not.
and I, and I know that's frustrating.
It
But
is.
these people who work in that office, especially unless they put it in writing, it's really hard for you for their words to replace what the written agreement is. You understand, when you already have a written agreement. And that is true as well. But when they send you that demand saying, hey, I know what we talked about, but now here's something else, then they're kind of whatever you guys try to agree orally, one, unless it's in writing, or two, um, you know, they send you a letter otherwise, then obviously you need to respond to that written agreement or written statement or demand.
Right. I'm not trying to. The thing about it is, I'm not trying to run from any of this.
No, I got it.
And I've paid my rent. I've always paid my rent on time, on up until, you
Because you
know,
had a situation. Listen, it's not a thing that anybody thinks anything bad about you. Mostly, I would say 90% of people just have financial issues that lead them to this problem. So it's not like it's not a personal thing. It's just personally happening to you, but it's not personal like we don't understand. It's
correct.
just that's just how it is. Now, I don't counsel. Are you guys still seeking a money judgment, just looking for the writ?
Just the writ, Your Honor.
So they were not looking for a money judgment. They're just looking for a writ. Okay.
I understand that, but we wouldn't be at a writ if they had honored their word.
I understand, but I don't know if their word would supplant the demand that you're saying that you received, stating that you needed to get more money, and you're saying that you have been behind as well,
Even with witnesses.
even with witnesses. Because what you're saying is they told you every 2 weeks you were doing that, and then they stopped, and then they sent you a demand saying we want it all.
This explanation from the judge is critical, and honestly, it's a masterclass in how eviction law works. Here's the legal reality. If a landlord initially agrees verbally to accept partial payments, that agreement can sometimes create flexibility. But the moment they send a written demand saying we want the full amount, that written demand resets the playing field. Why? Because written contracts and written notices carry more legal weight than oral conversations. Unless that modified payment plan is also put in writing, it's extremely difficult for a tenant to enforce it. The judge is essentially saying, even if they told you every 2 weeks was okay, once they formally demanded full payment, you were legally required to comply with that written demand. Without proof of a written modification, the original lease terms control. This is where so many tenants get trapped. They rely on conversations with office staff. They trust verbal assurances, but in court, the only thing that truly speaks is documentation. And notice what the judge asks next. Did you have all the money? That question matters, because if she had the full amount and they refused it, that's a different legal scenario entirely. But partial funds? Unfortunately, that's not enough. Tough, but legally consistent.
Comes the problem. Once they tell you we want it all, you don't have it all because their contracts generally demand that you pay that. Now, if they put it in writing and say, hey, this modifies the written agreement, boop-de-boop, that's different. That's
I'll go up there and get it.
I understand.
I go to the leasing office and get something in writing because that's what they told me. Like,
Right.
It's not fair. It's not fair. But I get.
I understand that you don't. Let me ask you this though: 100, right?
Mm-hmm.
Do you have all the money now? If you took away all the late fees, all the fees, did you have all the money? January,
I don't even.
December,
Fees.
November.
I gave them money in November, but of course not, because life still moves on. I have $1,000 to give today. They owe me $1,000, and I get paid Wednesday. I could give more money Wednesday.
I understand, but unless they're willing to enter into a consent agreement, ma'am, I can't force them to do so. Unless you're saying, "Hey, I had all the money, and when I demanded, and they just didn't take it," that's different than saying I had less than all they demanded, and then they didn't take it. Okay. Right. So I'm going to give you the 7 days, the 13th. There will be no money judgment. And that'll be the order, okay?
Well, dang. Okay. I guess I can't do nothing with that.
Well, don't have a money judgment. That's more beneficial than you may understand. All right? But I will go ahead and I'll draft up this one since it's a trial, and I'll get a copy over to you guys. You both are free to go. I believe, Attorney Sinkway, that's all your cases, correct?
Charlie, close my business.
So what you're saying, I have 7 days to get out?
It's 7 days before the writ of possession can be requested. Yes, ma'am.
Is there any way I can have 3 weeks to get out?
No, I have no authority to give you more than 7 days by law. I don't. Sounds crazy, but I don't. But I will get you a copy of the order. All right?
Thank you.
All right, thank you.
And just like that, the ruling is delivered. 7 days before the right of possession can be requested. No money judgment. That part is significant. A money judgment would follow her, potentially leading to wage garnishment or collections. The judge spared her that. But the eviction clock is still ticking. Let's break this down clearly. The lease expired and became month to month. Rent increased. Payments fell behind. A written demand for full payment was issued. Partial payments were not legally sufficient to stop the eviction. No written modification to the lease was presented. This case highlights a harsh but important truth. In landlord-tenant law, written agreements almost always override verbal promises. Judges are bound by statute, and as the judge said plainly, she has no authority to extend beyond 7 days. Emotionally, this is heavy. A tenant facing health struggles, a landlord enforcing contract rights. Legally, the decision follows the framework. Humanly, it feels painful. Now I want to hear from you. Do you think the landlord should have worked with her longer? Or once the written demand was sent, was the outcome inevitable? Should courts have more flexibility in hardship cases? Or would that undermine contract law? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.